That's not my question. My Lords, my Lady, just one point of clarification, lest I forget, of a matter raised by Lord Mance before the lunch adjournment, and that was about the case, the habeas case of Ramatullah, and my Lord Mance put it to me that we had accepted on behalf of Mr Ramatullah in those habeas corpus proceedings that his detention was lawful as a matter of international law. If we could just turn up the authority in Volume 1, Tab 6.
Not his detention by the United States.
Oh, I see.
His detention by the British government.
Yes.
Look at, for example, 9247.
Yes, that was the initial detention, but that wasn't the nature of the...
Isn't that what we're arguing about today?
Well, no. For example, in relation to Mr Ramatullah's claim, there is a claim in tort which is based also upon his transfer. Now, at the moment, Mr Eady doesn't actually raise Crown Act of State in relation to his transfer, but in relation to the transfer of the Iraqi civilian cases to the United States custody, Mr Sweeting does raise the issue of Crown Act of State in relation to that transfer.
I see. Now, I was looking at 9247 at D.
Yes, for that very short period of detention when he was in United Kingdom custody.
And also Lord Phillips's judgment at 9245, paragraph 108. Does it make any difference that the United Kingdom, having lawfully detained Mr Ramatullah in the field of battle, handed him over to the United States, an act not unlawful in itself, and so on? So I see. Anyway, that's the... You were talking about or thinking about the subsequent detention.
Yes, because that is the subject of these claims. Now, it so happens that for reasons unknown, Mr Eady is not running Crown Act of State in relation to the decision to transfer Mr Ramatullah.
Or in relation to the subsequent detention.
And therefore in relation to the subsequent detention.
So we're talking about the initial bit.
But in the Iraqi civilian cases, Crown Act of State is being raised in relation to that transfer. Now, given the nature of the arguments that Mr Eady is running today, it's very difficult to understand why he is not raising Crown Act of State in relation to transfer, because he has said that it covers acts done in the course of military operations, and this relates to transfer of a man in detention to the detention of another member of the multinational forces. And it's very difficult to see by what principle one can divide the act of detention by the United Kingdom from the act of the decision to transfer him to the detention of the United States. Be that as it may, the Iraqi civilian case does raise that issue. So, and of course, so far as his treatment in detention, the Geneva Conventions would have applied, and so insofar as he was mistreated, and that was pursuant, for example, to any policy of the United Kingdom, the illegality in international law might, or there may be issues of illegality in relation to international law in relation to his treatment. So, can I move over the Crown Proceedings Act, because we're not going to have time for that, and it's all set out in our case, and I think I gave the court the references before the lunch adjournment. So that is going to bring us then on to the critical issue in this case, which is justification for any rule that the court might find for barring the claim of the claimants in tort from going forward. Now, as we said earlier on, we accept that even if there was no defence, or even if that defence was not extinguished by the CPA, it's still open to the court to lay down a basis upon which the courts can refuse to enforce foreign law in the context of the UK's operations abroad. The defendant says there is a defence, and that's its starting point. Whatever the starting point, whether from scratch or whether on the basis of that pre-existing defence, we submit that there is a single principled approach that must be taken by this court in relation to the test of whether or not, or as to the contours of any possible rule of abstention. And this is because, however such a rule of abstention is characterised, it is, in essence, it is an immunity from suit. And we can see that by examining how it is that this case comes to be before the courts. So it comes before the courts through PILA, and that is in Volume 1, tab 9. Relevant section starts at section 11, choice of applicable law, the general rule. Having said at part section 9, the rules in this part apply for choosing the law to be used in determining issues relating to tort or for the purposes of Scotland delict. And at 11, the choice of law rules are provided for. They set down that the general rule is that the applicable law is the law of the country in which the events constituting the tort or delict in question occur. Then there is a displacement provision at section 12, which provides for circumstances in which instead of that applicable law governing the claim, the court can instead, where it is substantially more appropriate to do so by the comparison of the matters set out in A and B, it can apply the law of the other country, which it is more appropriate to apply. And then we have section 14, which is headed Transitional Provisions and Savings. And it is in subsection 3 that the Court of Appeal located any rule of abstention, any rule by which the court would refuse to apply the foreign law of tort. Without prejudice to the generality of section 2 above, nothing in this part authorises the application of the law of a country outside the forum as the applicable law for determining issues arising in any claim, insofar as to do so, one, would conflict with the principles of public policy. And then section 15, yes, critical provision, which makes it clear that the Act applies to claims by or against the Crown as it applies in relations to claims to which the Crown is not a party. So there is a very clear statutory route by which a cause of action in foreign law falls to be brought before the English courts, relating to the acts of the Crown abroad, relating to the acts of the Crown that are in issue in these proceedings. Now, if we then examine the nature of the rule of abstention...
What about section 15, subsection 3? Is that also relevant, potentially? Nothing affects any rule of law as to whether proceedings of any description may be brought against the Crown. Could that also reflect the Crown Act of State principle?
Well, it could affect the Crown Act of State principle, but one has to ask, what is the nature of the rule of law that is in question here?
Yes.
And once we have identified that it is not a rule of law which goes to the justiciability of the court, it is going to be a rule of law which necessarily prevents the court from adjudicating on a cause of action that would otherwise, or does otherwise, arise. It is clearly in the nature of, because what we are dealing with here is a claim which, or rather a rule, the application of which does not, as I indicated earlier on, have the effect of applying English law to the situation. It has the effect of disapplying any law to the situation, of creating, as it were, a clear immunity from suit.
So, I mean, section 15.3 seems to be rather more suitable in some ways as a home for a Crown Act of State doctrine, if there is one, than section 14.3, which simply switches you between proper laws.
Is there anything in the Law Commission report which resulted in this piece of legislation to explain section 15.3?
No,
I don't know the answer to that. I ought to know the answer to that because I was party to that Law Commission report, but
we didn't
my memory
find
is
the
not.
answer to that. But it would clearly apply, for example, to immunities that are preserved under the Crown Proceedings
That's it,
Act,
yes.
for example. It would obviously apply to those immunities. And I don't dispute that it would be capable of applying here. And as my Lord Mant says, it might be more appropriate in that it reflects the true nature of this rule, which is that it is it is not just a bar on the application of foreign law, it is the bar on the application of tort law in general, that be whether it be English law, foreign law, or any other municipal law that might be applicable. But it doesn't change Section 15.3 or Section 14.3, whichever prism or route one takes. It doesn't change the nature of what is an issue here. And what is an issue here is an immunity from suit in relation to the Crown, where they would otherwise be subject to the cause of action under foreign law or English law. So, as such, there is a very clear basis upon which such an immunity falls to be justified. And that is, and has been set out by the Supreme Court in Jones and Caney, and we'll come to it in a moment, but just before we do, we just have to reiterate again that this rule is completely incompatible with the way in which the appellants submit the court should approach the justification, which is on the basis of an incremental approach. And an incremental approach necessarily doesn't mean that the development will be by reference to what is proportionate, what pursues a legitimate aim. It's a simple step-by-step slow approach. So, for example, one of the matters that the defendant contended for as circumscribing the application of the immunity on the basis of an incremental approach is that the immunity will not apply in circumstances where what is at issue is acts of torture. And I understand from our discussions earlier on that it was understood that the defendant has also accepted that any form of ill treatment would actually justify the court in refusing to apply the immunity. I'm not sure that's right. I think what the position the defendant appears to have taken is that so far as we are concerned, we did not authorise any acts of ill treatment, and therefore we will not seek to apply the Crown Act of State doctrine to any allegations of ill treatment. But as to the question of principle, they appear to have limited themselves in their case to saying that the immunity does not extend to acts of torture. But that's an incremental approach, and it raises the question, if one is trying to look at this on the basis of a principled justification which pursues a legitimate interest and does so proportionately, why a limitation in relation to acts of torture?
Well, is the reason, or may the reason not be this, that the problem with which we are concerned arises from the fact that there are, as I suggested to you this morning, some sovereign acts, primarily military operations, which by their very nature are going to involve trespass to the person or to goods, torts. That doesn't mean to say that everything that happens pursuant to in the course of armed conflict or military operations has that characteristic. It is inherent in the conduct of military operations that persons may be detained, that persons may be killed or injured, that property may be damaged. It might be said that it's not inherent in the conduct of military operations that prisoners will be maltreated. Indeed, the whole of international humanitarian law is posited on the proposition that it isn't inherent and isn't lawful. Equally, it might be said that the occupation for the benefit of soldiers of private property, as in the Nissan case, was not inherent in the conduct of military operations. If one regards the doctrine as concerned with things that, although tortious, are actually inherent in the conduct of military operations, then most of the limitations which you describe as being exceptions to the principle don't actually come within it at all.
But that which is inherent in military operations and justifiable is defined by reference to international law. International law provides the power...
You've added the word justifiable. I simply said inherent in it. I mean, it is inherent in military operations that people will be detained.
What is not inherent is that they will be arbitrarily detained. And the international framework provides the basis for that detention to take place in a lawful manner, which is not arbitrary. And the question is, why should international law intervene when it comes to torturing somebody, but international law not intervene to displace the immunity or to render the immunity inapplicable in circumstances where somebody is arbitrarily detained?
Well, that raises some of the issues with which we're concerned on the other appeal, particularly in relation to grounds 5 and 6. If you take the simplest case, which is prisoners of war in an international armed conflict, their access to any kind of judicial oversight, which is the essence of non-arbitrariness of detention, is very, very limited indeed.
Yes.
A prisoner of war taken in an international armed conflict has virtually no recourse.
Well, that's one of the questions that arises for determination, because the IHL no longer sits in isolation on the international plane from human rights law. And following Hussein, the two have to march hand in hand, and there has to be modification of IHL by reference to the requirements of Article 5, and modification of Article 5 by reference to IHL. And so it's no longer the case, and that's one of the issues to be determined, that somebody who is a prisoner of war has the limited procedural rights to which you refer. So I again pose the question, why should an individual be subject to arbitrary detention without redress, but allowed redress in relation to an act of torture, and as I understood it before, any form of ill treatment that would be contrary to Article 3. And in my submission, that is the wrong starting point. The starting point is, why should they not have a right of access to court? That's where we have to begin, and we have to examine what justifications can be offered and have been offered for the argument that this immunity, with this limited exception in relation to torture, is what this court should uphold.
Well, they may well have such a right in the case insofar as reliance is being placed on the Human Rights Act. But what we are concerned with is defences or immunities, depending on how it pans out, to an allegation of private law tort.
Yes, but as we'll come to, private law tort has traditionally, in this jurisdiction as well as in many others, been the means by which the courts protect fundamental rights to liberty, to security of the person, and thereby the right not to be subjected to torture, not to be subjected to arbitrary detention. So the civil rights encompassed by these torts provide a valuable mechanism for protecting those fundamental human rights. So again, the question becomes, why should an individual not be able to have access to the courts in respect of rights that they possess qua somebody who is detained in that country, in circumstances where the detaining authority is not complying with the international legal obligations that circumscribe their right to intern, their right or the treatment that they mete out to the individual in question. And if we can look at Jones and Caney, we can see clearly that the way we have to approach this is to justify the immunity. Not start at the other end, not start from the proposition, why should the state be subjected to tortious liability? The state is subject to tortious liability unless an immunity can be justified and carved out, and that has to be on the basis of identifying the legitimate aims and so forth that it pursues. So the Jones and Caney case is at 4, volume 4, tab 29. From the head note, we can see that this was a case concerning the immunity from suit enjoyed by expert witnesses. The court can turn to paragraph 51 on page 10156 and read from C down to E in the speech of Lord Phillips.
Sorry, which paragraph was it?
It's paragraph 51,
Thank you.
C to F. So one doesn't start, in this case, with a defence that has existed for a long, long time, an immunity that's existed for a long time. You don't start from the proposition that you've got to justify getting rid of it. You've got to justify its continued existence. Lord Brown, at paragraph 63, agreed with the majority. Lord Collins, at 86, agreed at 10164, agreed with Lord Phillips and Lord Dyson. And Lord Kerr, we can see in paragraph 87, agreed also with Lord Phillips. And at 88, 4 lines down, whether or not witness immunity has had a long history, as to that I agree with Lord Dyson that this is far from clear, this court should not be deflected from conducting a clear-sighted contemporary examination of the justification for its preservation. This is particularly required because the immunity has its roots in a time when, as Lord Phillips has pointed out, it was not customary for experts to offer their services under contract or reward. So conditions have changed, circumstances have changed. That's precisely where we are in relation to the defence, if that's the route we come through. It was created, established at a very, very different time. And Lord Dyson, at 10169, at paragraph 108 through to 109, and the first line of 1110, and then we don't need to look at the first reason, but it's the second reason starting at 112 that is relevant, 112 to 113. And the first line of 114. So the starting point, the key principle embedded in our law, cornerstone of the system of justice, where there is a wrong, there should be a remedy. To deny a remedy to the victim of a wrong has always been regarded as exceptional. It requires strict and cogent justification, and you have to keep that under review. Now, in our submission, whether you are revisiting an established immunity or looking at whether or not to establish an immunity, the test has to be the same. It has to be justified as necessary and proportionate in present conditions. And those present conditions, the starting point in looking at them, are the principle that there should be a remedy, where there is a wrong. That sits together with the key right of access to the court. And the other principles, key principles that set the foundation for the modern approach, are identified in our case at paragraphs 50 to 75, core 12275 to 12283. And just by way of quick overview, the remaining four, in addition to remedying wrongs and right of access to the court, I've touched on this before, the role that the law of tort performs in holding the executive to account and subjecting it to the rule of law. Before the resurgence of administrative law, in the view of Dicey, private law was the means by which the executive was brought under the rule of law. And the fact that we now have a modern law of judicial review with a set of developed public law principles that confine and circumscribe what it is that the executive can do does not mean that there is no longer any ground on which to secure to somebody wronged by unlawful executive action a remedy in respect of that wrong. The role of tort plays a separate, or tort has a separate function, and its function is to protect fundamental rights to liberty and the security of the person. Public law doesn't do that. And related to this is the rule that the Crown does not itself have the power to alter the law. The Crown can only alter the law if and to the extent it is empowered to do so by statute. Now, this is less important now, this principle, because of the way in which the defence has been narrowed our understanding is that it's been narrowed. When one was looking at the original defence, it was effectively a self-certifying get-out-of-jail-free card, because all that the executive had to do was to ratify the act or make it an act of policy, or make it part of its policy, and then the matter would not be subject to the court's jurisdiction. But there is some role for this still. There is some role for this principle still, because according to the conception of this rule for which Mr. Eadie contends, there is a tremendous amount of uncertainty as to the scope of the acts that are caught by this principle, that the court must stand back in relation to the application of tort law where it is considering actions taken in the field of military operations. And one is left with the risk that in those areas, ultimately, it will be for the ipse dixit, effectively, of the executive to determine what acts do and what acts do not fall within that rule. But even if it's not left to the ipse dixit of the executive, there is nothing in the way that the principles are characterised by the Secretary of State, which would allow the court to know and determine on a rational basis which side of the line the different acts taken in the course of military operations fall. The next point, the third point, is that it is not inconsistent with public policy per se for foreign tort claims to apply against the UK government arising from acts done abroad. That's obvious from the terms of PILA itself and its express application to the Crown, but it goes further. For example, in Al Jeddah, in the Court of Appeal, Lady Justice Arden made exactly this point at paragraph 85. This is volume 1, tab 5, on page 9177. Paragraph 85, where she says it's not contrary to public policy to apply the law of Iraq to the tortious conduct of British soldiers simply because the British government might become liable in damages on the principle of vicarious responsibility. And she cites there Beachy and the Ministry of Defence. And we have within these proceedings. The concession of the government that it should be capable of being sued in relation to the acts of its British soldiers, it is vicariously liable. It's not contesting the allegation of vicarious liability. It is vicariously liable, it accepts, for the tortious acts of its soldiers, to the extent those soldiers' acts were not authorised. Now, that is a bizarre situation where no immunity falls to be applied in relation to unauthorised acts for which the state is vicariously liable, but tortious liability falls to apply to authorised acts for which the state is vicariously liable. What is the justification for that decision?
But, I mean, Beachy or Beaky or whatever how you pronounce it was a case of a rather collateral shooting in Kosovo, in Pristina, by peacekeeping soldiers, but nothing to do with peacekeeping as far as one can see. Perhaps I'm wrong about that.
They're there in the course of their military operations.
Yes, but they're hardly doing...
They were there in the course of military operations, but I don't think the killing occurred in the course of that which was authorised.
There was a demonstration.
No, it was. Their claim was they were acting in self-defence in a hostile and potentially dangerous crowd, yes. But, I mean, it's fair to say that Lady Justice Arden actually went on to say that this was a case of Crown Act of State, didn't she?
Beachy.
No, sorry, Al-Jeddah.
Yes, and that was for the reason, and we'll come on to it, that was because she considered that they were discharging their international obligations under the UNSCR. And in her view, and we'll come on to this, because they were discharging the international obligations, they should be free from domestic law because, in her view, sufficient protection was being given by the availability of judicial review, and they should not be hampered in their operations by being subjected to tort law. We'll come on to that. That takes us part way down to the justification that we, in our submission, say does apply, but it results in a disproportionate result. Outcome. So the last point we make is the separation of powers. And again, we've seen from the analysis of justiciability that the modern conception of the separation of powers is such that the courts can and do operate within this sphere. And when asking oneself why the courts should step back in relation to the law of tort, the general environment of in which the law is applied to the very self-same acts is plainly relevant, particularly when one comes to look at the justifications that have been offered for the immunity by the defendant. So, before we look at those justifications, I would just like to stand back and try and analyse some of the cases in which this immunity from suit would apply on the defendant's conception. So if we take the case of Mr. Belhaj, and we slightly alter the facts of his case to these. He was picked up by the British rather than information being relayed by the British, and he was flown off illegally out of the country he was in, and he was then taken to a black site in Afghanistan. Now, on my understanding of the doctrine for which Mr. Eadie contends, Crown Act of State would prohibit the court from entertaining any tort claims that he might bring in relation to his detention. And in my submission also, on their analysis, in relation to any ill treatment falling short of torture, insofar as that ill treatment was part of a policy that they applied. So we are looking here at hypothetical situations, but should the United Kingdom government decide that in order to secure information or intelligence, it is going to ill-treat in the way that it did, for example, with in relation to Baha Musa in Iraq, when it was applying hooding techniques which were held to be contrary to Article 3. The defendant's cases, unless they amount to torture, there is no basis upon which the state can be required to account and remedy that wrong through law of tort. The sort of situation which this conception, which is tied to sovereign acts, would exclude is a situation such as the case of Mullen, for example, so where an individual is picked up by, let's imagine in that case, the security services or the police, and unlawfully detained, contrary to the law of the country he's in, and brought back unlawfully to the United Kingdom in order to stand charge. Now, on my understanding of the way that Mr. Eady now conceptualises the case, that would not amount to a Crown Act of State.
Are you postulating an alien?
This is an alien.
So dealt with, because of course Mullen wasn't.
No, let's imagine he was an...
Yeah, but you're postulating an alien.
He was an alien.
Yeah.
But actually, as Mr. Eady said yesterday, the doctrine is going to apply whether you are an alien or not. Oh, he was Irish. But in any event...
He had a British passport, Miss Calvin.
whatever he was, on Mr. Eady's conception, the doctrine applies whether you are a British subject
Yes,
or
I
not.
follow that. All right.
So it doesn't matter, but I think that would fall outside. So, for example, if Mr. Belhaj, in Mr. Belhaj's case, we substitute for somebody who has gone to Syria from Britain, picked up in Syria, and then rendered off to Afghanistan, the doctrine would apply to him, the immunity. He would not have a right to bring a claim in tort. So, can we then turn to justifications? The characteristics that Mr. Eady identified, the sovereign act, such as entering a treaty, making war and peace and annexations, done in the conduct of foreign relations, which does not apply to acts in the UK, and the kind of sovereign acts, as I say, he identifies are annexation and so forth. The first difficulty that this rule encounters, which I've adverted to already, is it lacks any specificity. How is the court to decide what acts do and what acts don't fall within the framework of the immunity? Now, Lord Sumption says, well, any acts that involve the use of force, that is, any acts that involve the invasion of an individual's rights. But that begs the question, well, what is the justification for a rule that is targeted specifically at preventing one from bringing a claim in tort? Because that's effectively what Lord Sumption's criteria really boil down to. The individual is prevented from bringing the only types of claim he or she ever would bring in this context, in the context of military operations, namely those which involve the use of force upon his personal property. Well, that, as I say, begs the question of what is the justification for that rule? And the justification that has been offered and that we have to examine, there are two, is the one-voice principle and the argument that these acts take place on the international plane and international law is what governs. So, turning to the one-voice principle, the first point to make is that insofar as any weight falls to be attached to the one-voice principle, insofar as the courts do on occasion take into account the one-voice principle, it cannot possibly justify the courts in the context of modern conception of the rule of law and the need for wrongs to be remedied. It cannot justify an immunity of the uncertain scope and stringent nature for which the appellants contend. The first point here is that some of the matters that the appellants place reliance upon in seeking to show the importance that the courts attach to this one-voice principle are really no longer of any proper application to a modern setting. So, for example, Volume 8, tab 76, the defendant relies upon Lauterpacht, page 11. Sorry,
Got a flag number.
No, 76.
Yeah, tab 76, and I seem to have missed off my cross-referencing to the page, so if you bear with me. I'm sorry, my lords. Just bear with me a second. I think I've got it marked up on my computer. So, 11738,
Yeah.
page 390, we find halfway down the page, above the limitations, in the domain, so it's about 7 lines down, in the domain of foreign affairs, it entrusts the competent departments of the government with the right of exclusive decision not subject to judicial review. At the same time, although the doctrine of separation of powers is being in practice reduced to its proper proportions, the elastic principle of the division of functions necessarily remains. This division of functions is particularly necessary in view of the necessity of uniformity of acts and measures affecting foreign affairs. Both the government and the courts are the organs of the state, and for reasons of stability and convenience in international intercourse, require that a state should not address its neighbours in two voices. Well, this was something that was said a very considerable time ago, back in 1933, way before the developments that we've seen in judicial review, whereby the acts of the Crown in international relations are subjected to the legal constraint of the courts, which necessarily means the courts speak with with a separate voice from the executive. And we'd also say, in passing, the two justifications are hardly of the greatest weight. Stability is hardly guaranteed by permitting the executive to engage in acts that are wholly illegal, arbitrary, and...
Well, I don't know. I mean, I think you're being a bit unfair to Professor Lauterpacht. If you look at the left page, he says that the traditional doctrine of separation of powers is, to say the least, no longer a principle obtaining with axiomatic validity. Courts perform administrative functions and by judicial lawmaking encroach upon the domain of the legislative power, etc. And he continues that theme. But, I mean, his point is surely still one with some validity, namely that if you decide to invade or take forceful measures against another state, you hardly then expect that it and its organs will turn round and sue you on the grounds that you're acting contrary to the laws of the foreign state.
Well, acting contrary to the laws of the foreign state or the laws of of England, or...
It's just not realistic. You can't invade a state or take military measures and then be expected to comply with its laws. That's the thinking, isn't it? And and as to how, I mean, the two-voice principle or the one-voice principle is, I fully accept, no answer to anything, because the real question is, when does it have any validity? But Professor Lauterpacht here identifies as it as necessary in relation to acts and measures affecting foreign states. That's what we're arguing about. Whether that's a sufficient definition. But there is some force, isn't there, in the one voice?
Well, where there is force in the one voice principle is within the context of the court exercising its jurisdiction. So, for example, when it makes decisions in the sphere of judicial review, it will give effect to the one voice principle by, for example, conferring upon the executive a very wide ambit of discretion in relation to the conduct of foreign affairs. But what the defendant is seeking to do here is to use it to oust the court's jurisdiction completely. And it simply isn't capable of having that force, particularly given that the fact that the courts are speaking with two voices elsewhere in respect of the very self-same subject matter means that whatever weight is to be given to the legitimate, or legitimacy is to be given to the one voice principle, it simply cannot be served in these circumstances where the court is speaking with two voices in another area of the law. And the second point is, my Lord Mount said, well, why? Why should when one state invades another state, why should it be subject to the domestic law of that state? Well, international law itself requires the state to comply with the domestic law of the state that it invades. And this is so...
So would the position have been that under what you submit to be the present law, one would have had a right of action against the RAF pilots who bombed Dresden in February 1945?
Well, that's... If they acted in accordance with their international law obligations, then the answer is no. Well, and combat immunity is also another, that's another separate immunity in relation to negligence. But our argument is, if they act in accordance with international law, then no, then that is the precise basis upon which the court should step back. But if they're not, if they're flouting their international law obligations, if they're holding people arbitrarily and out with what it is by international law they're permitted to do, what is the justification? What is the justification for removing their right of access to the court?
On this submission, private rights of action are effectively being governed by international law. If you imagine a German householder suing an RAF pilot, I'm slightly surprised at the suggestion that the cause of action between them can be governed by international law or by anything other than the law of tort, subject to such modifications as English public policy requires in its own courts.
But the cause of action is not governed by international law. The question of whether or not they can avail themselves of their right of action is determined by whether the state has complied with international law. That is not the same as the cause of action being governed by international law at all. It is a rule of abstention by which the court decides whether they can have a right of access to the court in respect of their cause of action. It is not the enforcement of international law, and it is not a situation in which international law governs. But if I can go back to Article 43 of the Hague Regulations, these can be picked up in...
I mean, Air Marshal Park would have been vulnerable, would he, to an inquiry as to whether his orders were in accordance with international law, and if the domestic court concluded they weren't, then he would be liable under German law, assuming we recognised the relevant German law, which would presumably be don't damage property.
In the same way that the court would have to make an inquiry under the Human Rights Act. In exactly the same way, has there been compliance with his domestic legal rights under the Human Rights Act such that his detention and his treatment conforms to those legal constraints?
Well, wait a minute. How far have we got in under the European Convention on Human Rights in relation to war activities? Have we got to the stage where we
the Convention applies.
Adjudicate upon warlike activities?
Yes.
Was Bankovic gone completely?
No, the case of Hassan, so this is the case that
Yes, but that's detention,
is going to come up for consideration by this court. So
It has done.
So Hassan decides. So for a long time, it was argued or believed that in the context of war, the legal obligations upon the state are governed exclusively by IHL. And that has been settled in the case of Hassan to the contrary. The two bodies of law stand side by side with such modifications as are necessary in order for, so far as the HRA is concerned, the HRA doesn't make provision for internment, but insofar as that is permitted by IHL in the context of an international armed conflict, then the consequence of the Hassan decision is not that human rights law is displaced, but rather that it continues to apply, but in a modified form, which means that internment is not contrary to Article 5, but the protections of Article 5 continue to apply insofar as is possible.
But in your case, that applies not just to detention, you say that applies across the whole field of military activity.
Yes. So another issue that is going to come up is going to be the reach of the jurisdiction of the Human Rights Act in the international plane. But as matters stand, if somebody is, for example, detained in custody pursuant to an order that they be interned by the British troops in Iraq, if somebody was, then according to matters as they stand from Strasbourg, then the Human Rights Act reaches to the circumstances of that detention. And the British state is accountable. So if that is so, if the Human Rights Act does reach, what is the justification for saying that an individual's rights to personal integrity, personal security and liberty as guaranteed by their municipal law should not apply? In our submission, the answer is strictly limited to what is necessary to pursue the legitimate aim here, which is to ensure that the state which decides to invade another country is not inhibited from taking the steps that it is entitled to take under international law. That is the mischief, that is that protection is the only mischief, as it were, that the fact that these acts take place on the international plane, the fact that these acts are governed by international law, can justify the courts in seeking to avoid. The simple fact that these acts are taking place on the international plane, which is the justification that Mr. Eadie puts forward for this rule of immunity, doesn't take him anywhere, because the courts routinely subject those self-same acts to its jurisdiction in relation to human rights law, in relation to habeas corpus, despite the fact that those acts are taking place on the international plane. So something more is needed. Yes, can we look at Article 43 of the Hague Regulations? And that is in Al-Jeddah, in volume 5, tab 42. And it's at paragraph 32, page 10824.
108 what?
10824, volume 5, tab
42.
42.
42.
So paragraph 32.
Yes?
So This is the very body of international law that the defendant submits is what regulates their conduct, and therefore they should not be subject to domestic law or municipal law. And it requires states.
But aren't these articles dealing with periods of occupation? There was no occupation in Afghanistan, was there?
Yes, but we're not just dealing with... Yeah, but we're not just dealing here with the situation in Afghanistan. We're also dealing with the situation in Iraq, where there was a period of occupation.
Post-cessation, post-hostilities, though.
Yeah, so this is post the hostilities. So there's nothing offensive to international law to require states to comply with domestic law. On the contrary, international law obliges them when they occupy to do exactly that. So the one voice principle just cannot do the job of justifying this restriction, because you can't ignore the fact that the court will be looking at these self-same acts through other legal prisms and speaking with two voices. What purpose can can a restriction serve in aid of the one voice principle in those circumstances? We submit that the Court of Appeal was quite right to recognise it simply has no role to play in relation to these cases where the court's jurisdiction already reaches. So we don't even get, as it were, to proportionality. It simply is incapable of serving that purpose, this immunity. But just for good measure, there are two controlling factors that the defendant put forward, which in support of their submission that any such rule of immunity is proportionate. First was, it's for the court to decide if each element is satisfied, or if, rather, the circumstances in which the immunity should apply are satisfied. And that just brings us back to the point again that by what test? What are the acts which fall on the immunity side of the line, and what are the acts that fall on the other side of the line? How is the court possibly to decide? And the second justification is that Parliament could modify it. Well, that is no guarantee of proportionality. Parliament can't be compelled to modify it. If the rule is disproportionate, then the court needs to strike it down and not leave it for Parliament to do. It is a rule of the common law. In the end, on this point, really, the appellants can do no more than appeal to the decision of the Columbia District Court of Appeal in the Macaulay case. And that case, as we saw yesterday, that concerned whether or not the writ of habeas corpus could lie in relation to somebody who was detained in Bagram. Well, our courts take a fundamentally different approach. They do permit the writ of habeas corpus to run in relation to those circumstances of detention. See Mr. Ramatulla's case. And one simply cannot take from those very, very different circumstances the necessary measure of force which the defendants require for the one voice principle to justify this rule. And then the second justification is these are international acts which sound on the international plane. And we've talked about the Hague regulations and the fact that the fact that international law itself requires compliance, so it's very difficult to see how international law could justify shutting out our courts from applying that domestic law that states are required to comply with. Secondly, the discussion yesterday was why should the question that was posed yesterday was why should military forces be subject to the vicissitudes of local law? Well, if one doesn't want to subject them to the vicissitudes of local law, then subject them to the vicissitudes of English law. But that is not what this rule does. This rule bars them completely. And so again, we come down to the question, why. What is the possible justification for that total bar of a right of access that they enjoy? So, can I come to our conception of that, of the rule of immunity, a conception that in our submission meets a legitimate aim and does so in a proportionate manner. In the modern world, with the growth of international cooperation, through the operation of the UN particularly, together with the increasing reach of international law, it is both legitimate and important that our courts do not operate in a manner that undermines the ability of the executive to act in accordance with its international law obligations and powers in the field of its international obligations. If the executive has to account to those who are harmed when it complies with its international obligations, that is what will happen. But equally, that has to be balanced against the importance of the right of access to the courts for individuals who have been done wrong for a remedy. So a rule which seeks to prevent an outcome by which the executive is hampered in the field in relation to the discharge of its international obligations and powers plainly seeks a legitimate aim. It serves an important public interest. And this is what drove Lady Justice Arden's reasoning in the Al Jeddah case. I said we'd come to that earlier, and if we could just turn that up now. It's in Volume 1, Tab 5. Paragraph 108. On page 9182. So firstly, in my judgment, Al Jeddah number 1 established that the United Kingdom was entitled and bound under its obligations under Article 103 to intern persons where this was necessary for the internal security of Iraq. Internment for this purpose would clearly qualify as an act of state. My conclusion is that, and we must remember that she is here dealing with a non-justiciability conception. My conclusion that the act of state is a defence here does not go wider than this. It applies, in my judgment, because of the overriding force of the UNSCR. If the courts hold states liable in damages when they comply with resolutions of the UN designed to secure international peace and security, the likelihood is that states will be less ready to assist the UN to achieve its role in this regard, and this would be detrimental to the long-term interests of states. And then she says the individual is sufficiently protected in this situation by compliance with Geneva 4. By virtue of CPA 3, there had to be compliance with Geneva 4. It's thus not correct to say the executive had unfettered powers of internment. A decision of the executive in breach of G4 could be remedied in this jurisdiction through the process of judicial review, and it may also constitute a criminal offence. So for that reason, she says, the law of tort should not run. But she didn't go on to consider whether there is a more proportionate and a less restrictive way to achieve precisely the same object. And in our submission, the consequence of that was that she applied a rule of abstention that is disproportionate, and this is so for two reasons. The narrower rule for which we contend ensures that the legitimate aim is met. It ensures the executive is not hampered or constrained in meeting its international law obligations. It guarantees to the executive that the courts will not interfere when they do so, but it ensures that the rule of law and the right of access to the courts is enforced when there is no justification for the court to refuse to exercise its jurisdiction. That is, when there is a failure to comply with those international law obligations. And it has this
Well,
adding...
I'm not following you. The premise of this reasoning is that the UK was complying with its international obligations, indeed was bound to do so. So why are you referring to situations
Well, for example, she
where there's a
didn't
breach?
consider compliance with the human rights obligations, and it may be she didn't consider it at that time because she wasn't, the law hadn't been clarified. But I read this as saying, if she was saying it is only where they do comply, then we would adopt this, and we would say that that is absolutely right.
But I mean, you're saying it's not enough to comply with international law for there to be an act of state. You've got to comply with human rights law, and you've also got to comply with local law.
No, human rights law is part of the international law obligations.
Yes.
So the international law obligations are made up of the obligations under IHL and the obligations under
So it's Hassan
human rights
type
law.
synthesis, yes. Hassan
That's
type.
what we submit you have to comply with. We obviously don't submit you have to comply with local law because this is a condition precedent to the application of local law. So it's not necessary to look at local law at this stage. That comes at a later stage.
It does sound very attractive to say that one of the limbs of this should be compliance with human rights law, but then if there's not compliance with human rights law, you've got your remedy anyway.
Well, that's why one has to be very, very careful. We're looking here at the development of a rule of immunity that will embed itself in the common law, come what may. Now, at the moment, there is a Human Rights Act, but we don't know if there is going to remain a Human Rights Act in this country. And well, this is a serious point because it is a point that Mr. Eadie makes again and again and again. The common law, as the Supreme Court has said in the Michael case, in the Van Colley case, should develop quite separately from the Human Rights Act. It protects civil rights, and it is concerned to develop doctrines that operate independently of the existence of the Human Rights Act. And so that is why, put the Human Rights Act aside,
If you're right, and the common law must, by some route or other, adopt the principles of the Convention, whether there's a statute called the Human Rights Act or not, then Lord Wilson's point is the same, isn't it? You're home and dry anyway.
Yes, but what one's asking here...
What you want is something beyond international law. You want the local law.
No.
Don't you?
We want local law only in circumstances where international law is not
Well,
complied
I've got
with.
that, yes.
So therefore one would have, it is correct to say, as things stand at the matter, one would have the Human Rights Act and a remedy under that, and one would then have a remedy under local law. But the point that I'm seeking to make is that as a matter of principle, the fact that at the moment we would have that is not a reason for the court not to develop the common law by reference to the protection of the right of access to the courts for the civil tortious rights that are in issue. And that's exactly the approach that the court has taken in relation to questions about whether or not the law of negligence is to be developed in conformity with the new rights that have been domesticated under the Human Rights Act. And the court has repeatedly resisted that for the very good reason that the common law is the common law and it has its own path to development. And one can't look to this separate body of law as a basis for developing it. So the issue for this court is, and remains, firmly one of, does the right of access to the court that this individual enjoys under PILA, is there a justification for that right of access to be shut down? And the fact that there is a Human Rights Act does not provide any justification in our submission. Can I just quickly say there is one other point that this rule of immunity important function that it serves, because this rule of immunity solves in one simple test the problem which the appellants' flabby rule, I call it, flabby rule produces, which is the problem of how you decide which side of the line the acts in question fall. The determination of which side of the line those acts in question fall is resolved by reference to whether the acts comply with international law or not. And then one is left with no problem any longer about tying the scope of the immunity to its justification. It is perfectly well tied together in one single, simple concept. I'm very aware that I am now running out of time. So just...
That is 8 minutes fast.
Oh, it's 8 minutes fast. I'm grateful. I keep forgetting. So can I then turn to Article 6 very, very, very briefly? The Court is familiar with the principles under Article 6. In a sense, we don't need to go there because the justification that is required under the common law through the requirements laid down in Jones and Caney avoids the whole complexity of the procedural substantive bar issue. But in any event, we submit that this unquestionably falls on the procedural side of the dividing line. The case of Markovich, which is at volume 7, tab 57, page 11426. I won't take the court to it now, but in the concurring opinion of Judge Bratzer and Judge Rozakis at 0117, page 11466, it's worth reading that paragraph to see how the distinction is drawn. And in our submission, what is being described there is a conception of a rule of justiciability. These matters are not justiciable because they are political, and we are not in that realm for the reasons that I have given earlier.
Sorry, we're not in the realm.
We are not in the realm of these being acts that are purely political decisions.
Yes. Well, it was slightly odd because it's exactly the same, is it not, factual situation as the present. So you have to say that Markovich was wrong in its application of the test, don't you, at an international level?
The difficulty is that that is precisely the situation, because what the court then did in Markovich is they gave a wide margin to the domestic court as to the interpretation and application of Article 6. And yes.
Well, they accepted the categorization which the Italian court had given of the relevant Italian rule as a rule of substance, which harks back to the point that Mr. Eady made yesterday, that a rule of substance may consist in a defence or in an absence of jurisdiction. And it was the latter that the Italian court had held was the correct description of the rule before them.
Yes.
And the Strasbourg court said that was essentially a matter for the Italian court as the ultimate judge of Italian law to decide.
But we simply repeat our submission that this is an immunity from suit in respect of an otherwise available right of action under PILO.
Well, one can go on arguing about this ad infinitum as one sees when one reads Judge Costa's opposite view. And, I mean, Judge Bratzer accepts that the dividing line is not easy to apply. Can I ask a different question, which I'm reminded and which will probably give a heart attack to those who've been through the exercise of looking at foreign civil law. But Markovich says, applying the concept of act of government, a familiar concept in systems of civil law, whereby political acts of government in fields including international relations, foreign policy, and the conduct of hostilities are not capable of being reviewed by the domestic courts. Well, Markovich is an example of that, but it does strike me as rather strange that we're asked to decide this again without any idea or better idea as to quite what is covered by an act of gouvernement and when that's been applied. Has anyone thought about that?
I'm afraid we have.
No.
But all I would say is that different legal systems operate in different ways. They have different conceptions of the
I
separation
know, but you'd
of powers.
expect on something like this, surely, and Markovic is a ray of light which gives us an insight into one area, and it was accepted at the international level, and it's quite interestingly comparable. One would have thought that there might be other jurisdictions which are quite close to us, which have wrestled with this sort of problem. One would have hoped that we came to roughly similar results, but I don't wish to put you through to too many hoops, because I know how difficult it is to get the material, and probably expensive too, but I do think it might be something we might want to think about a little.
Yes, we can do that. So, my lords, my lady, unless I can be of any further assistance, those are my submissions.
Thank you very much. Mr. Hammer.
My lords, my lady, can I adopt in their entirety my lady submission on behalf of Mr. Mohammed? Can I draw to the Court's attention 7 features of Mr. Mohammed's case that we say help illuminate the proper approach to Crown Act state, not least by demonstrating, we say, how unpalatable the doctrine contended for by the appellant would be if accepted. I seek to do that in Mr. Mohammed's case for 2 reasons. Firstly, because we have the benefit of factual findings made at trial. And secondly, because Mr. Mohammed's case is a hard case. It had to be accepted on his behalf for the purposes of getting before the court that the court should proceed on the basis that there were reasonable grounds for suspecting that he was a Taliban commander. So if the points that I'm going to make sound good for Mr. Mohammed, the position is a fortiori for those with perhaps more attractive factual points. I'm going to make the points and give the court the references to the factual findings of the court below and where they were affirmed by the Court of Appeal. The first point is this. The detention of Mr. Mohammed was deliberately done under a policy that was out with and inconsistent with the detention policy of the force mandated by the United Nations Security Council, the ISAF policy. References High Court, para 420, MS 6385, Court of Appeal, paras 67 to 72, MS 7977, and paragraphs 153 to 157, MS 7998. Point 2, the United Kingdom detention policy was developed expressly with the knowledge that it lacked any legal basis in international law or local Afghan law.
And all of these points were the subject of the appeal that we heard in February.
They were, of course, Lord Clark wasn't with us on that occasion, and of course I accept I'm repeating many points that I made, but they are relevant, we say, to the Crown Act estate when you're considering how does this doctrine, what's the scope of this doctrine, how would it work in practice? If I can give you the references to that, you'll see that in the judgment of Mr. Justice Leggett, paras 418 to 19, MS 6384, Court of Appeal, paragraph 153, MS 7999. Third point is this. A significant proportion of the detention was in violation of international law standards. Specifically, Mr. Mohammed was held for a period contrary to international humanitarian law for the sole purpose of interrogation. High Court references, paragraph 333, MS 6361, and paragraphs 418, Roman numeral 3, MS 6384, Court of Appeal, paras 248 to 250, MS 8026. A fourth point is that Mr. Mohammed was held without any of the minimum core procedural protections found both in international human rights law and international humanitarian law. In particular, he was not afforded an opportunity to make representations challenging his detention. He was not allowed access to family or to lawyers, and he had no means whatsoever of challenging his detention before either the Afghan or the English courts. High Court references, para 356, MS 6367, paragraphs 334, 336, 342, MS 6362 to 3.
Do you think you could put all this on a bit of paper
court.
And send us that round.
I will do that. And that's,
Thank you very much.
shall I not give you the references now to move on, my lord?
Well, I think it would be more helpful to have it
Yes.
correctly put in typescript.
I shall do that.
Inaccurately written down.
Yes. What I will also do under this head is highlight for you the position taken by my learned friends in their most recent submissions, which were submitted on the 4th of April, dealing with grounds 5 and 6, in which they set out that Mr. Mohammed was not entitled to habeas proceedings, to bring habeas proceedings for the English court, and he was not entitled to make representations about the legality of his detention. My fifth point is that that no doctrine of Crown Act of State precludes Mr. Mohammed's claim under Article 5, even if the principle in Hassan can be extended in the manner contended for by my learned friend Mr. Eady to cover a non-international armed conflict. The court would still have to assess, and indeed in his case has assessed, as to whether or not the detention was in compliance with IHL, both substantively, i.e., was there a power, was it necessary for imperative reasons of security on the facts, and also procedurally, was it in accordance with IHL. In other words, the court will have to assess, under a Human Rights Act claim, every aspect of detention and award just compensation insofar as it was not in accordance with IHL. And of course, we accept entirely that the position under the HRA does not dictate a result in common law, and doesn't mandate that there is a reflective position in common law, but it cannot be irrelevant, particularly if one is asking, are these matters that the court should, as a matter of principle, grapple with? The answer to that, we say, is provided if, in fact, they are going to be grappled in any event. My sixth point is this. The difficulties that arose in Mr. Mohammed's case that the Ministry of Defence faced in respect of detaining somebody they perceived to be dangerous for longer than the ISAF policy permitted should not of itself, those difficulties, be the basis for the creation or development of common law doctrine. That is not least because, as the courts recognised below, the problem in Mr. Mohammed's case was one of the appellant's own making, because it failed to secure a legal basis that could have been readily available to it. And I shall give the court the references in the judgments below to that. But what I could, if I may deal with, is the example raised just now in argument about Dresden. It might be thought that an advocate always knows they're in some difficulty if a judicial question is based upon a fact around World War II. And let me deal with it, if I may. Firstly, the position in these courts has always been that there is a difference in cases arising out of war and non-international armed conflicts. And there's a series of cases that the court will know in respect of access to the courts during the last war by enemy aliens. So there's a difficulty to begin with. The second point is that the principle of combat immunity, most recently dealt with by this court in Smith No. 2, would knock out any claims for negligence. The next point is, on the basis of the submissions made by my learned friend, insofar as any bombing campaign was in compliance with international law, there would be no claim because the doctrine would apply for reasons that are accepted. And my final point on this is insofar...
Sorry, what was that point?
That insofar as the actions over Germany were in conformity with international law,
Yeah.
no claim would lie, for the reasons set out by my learned friend.
And if they were not, the claim would be governed by German law?
Well, if they were not, the government could, if we'd gone through all these steps that I've just set out, and if there was still a claim in foreign law, then no doubt the government could do that which it should have done in Mr. Mohammed's case, which is legislate to preclude any claims if they were deemed to be offensive.
But in the absence of legislation, what would have been the result if there had been a breach of international law?
For the reasons I've just given, we would never have got to that point. But if notionally one could still get through all those hurdles, then the claim would have to be dealt with.
But under German law?
Yes, because the starting point under conflicts law is the law applicable, is the law where the damage occurred. And if you got through all those hurdles, that's where you would end up. But of course, today, if that case is dealt with under the 1995 Act, one would anticipate it would be knocked out on Section 14.3 grounds. So there would be a host of hurdles that would preclude the Dresden claim successfully coming before the courts. And so that is not an example that can be used to identify the doctrine that my learned friend contends for. This is not the cases, all the different range of cases that are before you are primarily not about IACs. Mr. Mohammed's case is the United Kingdom coming in by agreement with the Afghan government in a time of non-international armed conflict, and indeed expressly agreeing to comply with the Afghan law and to act with respect and in conformity with it. Now, my final point, my lord, my lady, is this. There is no dispute that the doctrine doesn't apply to torture, but this court should be very slow indeed to treat the protection from arbitrary detention as anything other than a fundamental human right that requires jealous protection by our courts. Now, of course, as we have accepted throughout in Mr. Mohammed's case, internment is a common feature of all forms of armed conflict. But it is one that is only sanctioned in extremis, and it always, but always, requires a legal basis. And it always, but always, requires minimum procedural protections. And absent those, it is arbitrary detention. And arbitrary detention is not simply a fundamental breach of human rights. It is also a breach of the Geneva Conventions, a grave breach of the Geneva Conventions, and a war crime. Now, the reason for that is in part because it's long been recognised that when people arbitrarily detain others, it leads to the risks of the range of human rights abuses, not least torture. Now, the MOD, my learned friend's stark position in respect of Mr. Mohammed's case is that United Kingdom forces operating in an IAC abroad may automatically intern people on security grounds without having any regard to local law or international law, without having in place any UK legal framework authorising and regulating such detention, with no rights for detainees to be heard, no access to legal advice, no right of review by a judge or other or impartial authority, and no right, see their latest submissions, to habeas corpus. Detention may continue on their case until the end of the conflict, in circumstances in which, as this court will well know, non-international armed conflicts can last for decades. What is required is a lawful basis for detention. Absent a lawful basis, it is a detention that is incompatible with English common law. Detention without a proper lawful basis has for centuries under the common law been, in the words of Lord Nichols in the Belmarsh case, anathema to our common law, and tort claims have historically been the means by which accountability has been secured. As with foreign act of state, my lords, my lady, we submit it would be invidious if a common law doctrine that on any view is of hazy provenance and uncertain scope was developed to sanction and immunise acts that have hitherto been considered irreconcilable with our common law tradition. My lords, my lady, unless I can assist you any further, those are the submissions on behalf of Mr. Mohammed.
Thank you very much indeed, Mr. Hammer. Thank you. Mr. Eady. My lords, my lady, a couple of tiny points to start off with. The first is to urge, if I may respectfully do so, a bit of a note of caution in relation to my learned friend Miss Kaufmann's whistle-stop tour through some of the academic commentary. The basic theme that she was developing, or appeared to be trying to develop, was that if you look at those academic commentaries to which she took you, and indeed some of the cases to which she took you, including Pedler and Johnston, they supported the proposition that they were analysing the Burren and Denman principle, in effect as a principle of non-justiciability. To some extent, that's question-begging, because it asks the question, what does non-justiciability mean? But a little caution in relation to both the academic commentary and Pedler and Johnson in particular, because even on its own terms, those academic commentaries in other parts make it entirely clear that they're dealing with a principle which excludes liability at common law or provides a defence for the purpose of liability. So even in its own terms, we respectfully submit that the properly and fairly read and fully read, those academic commentaries do not support the proposition for which they were advanced. And Pedler and Johnson, the same point can be made. You focus very much on Lord Sumner, but you will recall in Nissan that one of their lordships, I think it was Lord Reed perhaps, cited quite a long passage from Pedler and Johnson, which culminated in a citation of Burren. And then they went on to cite Burren and Denman. We can go back to the passage if necessary, but it's perfectly evident from that quotation, which their lordships in Nissan took as being, in effect, the ratio of Pedler and Johnson, and from the quotation from Pedler and Johnson that is relied upon in Nissan from Lord Findlay, and that's at page 9076, particularly between E and F. It's perfectly evident that they were treating Pedler and Johnson as treating the Burren and Denman principle as being a defence. So a little caution in relation to those. A little caution also on an entirely separate subject matter in relation to the question of transfer and Ramatullah. My learned friend is right that on the preliminary issues in Ramatullah, they focused solely on the detention aspect and did not focus on the transfer aspect. But can I simply refer you, without inviting you to turn it up now, to footnote 3 on the very first page of our case, which makes it entirely and expressly clear that, in view of the stage that the pleadings had reached, the defendants, that's us in Ramatullah, had reserved their position in relation to transfer, but in principle we say the position would be as in the Iraqi civilian litigation, that Crown Act of State applies, subject to the defendant showing that any transfer was authorised pursuant to a lawful policy. So we've effectively reserved the position. So there isn't, as it were, some latent, hidden and sinister problem of principle in relation to the transfer of Ramatullah. It's simply a question that the pleadings haven't quite reached that stage yet. Can I turn rather more relevantly, and I'm going to try and focus the majority of my reply on this aspect, to the question whether or not, the important question, whether or not we assert that international law is in effect a fifth condition, the Lord Wilson question, which is obviously important. And it's obviously important that I make clear, as I obviously didn't do in opening, that we do not advance compliance with international law as a fifth condition or a fifth precondition to the application of Crown Act of State. Our case is that international law has a role to play in this sphere, in the sense that any action that should be taken in relation to those acts that satisfy our four characteristics fall to be governed, and appropriately to be governed, at the international legal level. And so it may be relevant to ask whether the act is subject to international law, because that might help you to define the relevant characteristics of the act, including whether it's a sovereign act of the requisite type.
It's easy to understand that distinction before the development of international human rights law. One could see, international law is the law of relations between states. If it's governed by the law of relations between states, well then the remedies should be, well, either diplomacy or going to war or international tribunals. That's easy to understand. Once international law starts developing in a way that recognises rights of individuals, it's a little bit more difficult to draw that distinction.
My lady, I entirely accept that point, and of course it's become a more complicated question. Now international law has moved, as it were, from the sphere of sovereign to sovereign, and seeks now to govern international relations. But I think my answer of principle to the point my lady puts to me is that it still remains for domestic systems to make decisions about the extent to which even individually focused international legal rights should be given effect to under their domestic legal systems.
The remedy for international human rights infringements is to an international human rights tribunal.
Exactly so, and one can test that proposition by focusing on the differences, such as they are, between the ICCPR for example, to which the United Kingdom is a signatory and which it has ratified, but which is not part of domestic law, other than as a species of international law coming into the HRA, compare that to what has happened in relation to the ECHR. I mean, the ECHR, we all know, at a point after the development that my lady has just referred to, was still being sought to be introduced, principally by Lord Leicester and David Pannick, into English public law by a variety of more or less subtle means, including in cases like Brind, and the courts set their faces against that. Until, and that is why it was passed, the Human Rights Act was passed. But the Human Rights Act was the necessary ingredient for bringing those individually focused international legal rights into domestic law. And so we do respectfully submit that the point about certain acts being governed on the international plane remains a good one, and one bears in mind in relation to both Afghanistan and Iraq that it isn't just UK relations that are engaged, UK interests that are engaged. It might be thought that Afghanistan, to take that as an example, Afghanistan's interests are just as directly involved in the question whether or not Sardar Mohammed should have been released after 72 hours, or should be able to claim damages under English law after 72 hours, with the money then flowing back to be spent as he sees fit, if appropriate, having been released under his local legal system. It remains entirely competent, would have remained at all times entirely competent to Afghanistan to raise, in relation to his detention, a complaint at the diplomatic level, complaint based on diplomatic protection. But we know from the military technical agreement to which I took you in opening that they did not do that. What they instead did was, having invited ISAF onto their territory, to facilitate ISAF's conduct of the necessary, indeed essential for the purpose of preserving the peace in Afghanistan, ISAF's necessary mission, including conferring, as we saw in the MTA, equivalent immunity to the immunity that would apply to UN experts, namely full-blown immunity. There is, of course, I'd say it's to be governed on the international plane, and that's the principal relevance of it. There is, of course, a separate question, which my lady pointed out in discussion earlier on, which is how, if at all, that international position ended up being capable of being dealt with or enforced. That's a slightly separate question to whether the body of law is appropriate to be applied. There's then a separate question as to the extent to which one can enforce it, and if so, how. A separate set of questions, but I don't think that actually touches this issue. What my learned friend seeks to assert is that before Crown Act of State can apply, it is necessary for it to be demonstrated that the act in question, be it the use of lethal force or an act of detention under, for example, the UNSCR, that is compatible and compliant in all respects with all aspects of international law. And failing that, she says, the ordinary conflicts rules and choice of law rules should apply, which means Afghan law should apply. And the first principal difficulty we respectfully submit that exists in relation to that submission is the one pointed out by Lord Wilson, which is that it's a pretty odd principle, if that's right. The question at heart is about, that we've been debating over the last 2 days, is about which system of law should govern. In essence, the choice there being between municipal law on the one hand and international law on the other. But the consequence of my learned friend's argument would be that the court would have to determine whether or not there had been a breach in relation to the relevant act of international law, and the punchline of that, if there had been a breach, would not be to seek to provide a remedy for that breach of international law, but would be to open the door for the application of a totally different system of law. In our case, Afghan law. I mean, one can test the absurdity of that, or the oddity of that approach, by positing this situation. Suppose, for the sake of argument, that the relevant international law said you can detain people in armed conflict. Suppose the Geneva Conventions or the UNSCR or both said you could detain people in armed conflict for 4 weeks, and a person was detained for 3 weeks and 6 days, And suppose that the relevant local law said you can only detain someone on security grounds, but you can detain someone on security grounds, but only for 24 hours. You would have under this exercise to go through the exercise of asking how long have they been detained for. They've been detained for a single day less or over the international legal position, and then back you go. And the consequence of that is not that they get damages, as it were, or some remedy for the 3.5 weeks for which they've been improperly detained under international law, but suddenly they get damages from 24 hours out. But all that does is to illustrate the principal difficulty of seeking to put in international law as a precondition to working out whether local municipal law, brackets entirely unsuitable, should apply. The second principal difficulty, it might be thought of my learned friend's argument, is that she positively denies that international law governs or should govern.
I don't think that example would work. I think then you'd be detained in accordance with international law for 4 weeks, and you'd be 1 day over, so you'd only get 1 day's damages. You wouldn't get down.
Not on her argument, because this is a precondition to the application of Afghan law, which says you can only be detained for 24 hours.
No, but the detention is divided into infinite slices, isn't it? You look at each piece of detention separately.
Well, my Lord Mayor, one can have an argument about that, but you get the basic point, which is the rules of international law.
Well, I do.
Governing the relevant thing, in other words, detention or the use of lethal force or whatever it may be, can be fundamentally different from the rules of the local municipal law as it applies. Indeed, they're very likely to be in our context, because in the context of armed conflict, one by and large has a set of international legal rules that operate as a specially designed lex specialis, whereas local law tends to be inherently unsuitable because it's to do with shopkeepers and citizens' arrests and the use of force in self-defence rather than proactively in a military operation. The second principal difficulty with the sequence of analysis that my learned friend asserts is the correct one, namely, this is a precondition, look at international law, see if it's been complied with, is that it precisely cuts across the one voice and separation of powers rationale that underline and underpin the doctrine if it applies, i.e. the Crown Act of State doctrine, and it cuts across it by inviting the court to rule on the legality of international law for the purpose of determining whether the doctrine, which is based on that justification, applies at all. So you are, as it were, inviting the court to do something which might cut across the very rationale for the principle as it might apply later on in the analysis, which is a pretty strange way of analysing things. Third principal difficulty, the one mentioned by Lord Mounts, it would drag through the development of a common law principle of this kind, it would drag the English courts precisely into territory where they have been, because we have the distinction between monist and dualist systems. It would drag the English courts precisely into territory that they do not want to go in and constitutionally should not go in to without parliamentary permission or some other reason for good reason for going there, namely to rule on issues of international law. And it is one thing, obviously, for international law to have to be ruled on when you're dealing with a human rights issue, when you're considering the nature and content of the ECHR rights, which sometimes allow for one to look at international legal conventions. The UN rights of the child have been before the court recently. It's quite another to simply say, build in, as part of a common law set of principles, a precondition which would result in the English courts being dragged into ruling on international law in a context as controversial and difficult as armed conflict.
Well, I take what you say about the context being difficult and controversial, but your submission sounds like the reluctance of the English, not reluctance, the refusal of the English courts to recognise rights created under international law unless they've been translated into rights in domestic law. But your submission looks like saying, but they must recognise immunities resulting from international law. It looks a bit as if you're trying to have it both ways.
Well, the immunity that we rely upon is an immunity squarely developed by the domestic courts as a part of the common law, recognising that some acts are more appropriate to be dealt with on the international legal level. I don't need to rely upon any particular substantive content or principle of the international legal framework to underpin that submission. In other words, to base the immunity, I simply submit that the English doctrine of Crown Act of State is based on the recognition that some acts are appropriately to be judged by that system, whatever its content may be, rather than the domestic municipal legal system, local law or English.
So you're contending for something which has to do with the nature of the Act, rather than something which may or may not be governed by international law? Because it may not be.
It may not be. My lady,
There may not be any applicable international law.
there may not be any applicable international law, in which case you're in the territory you're in. Perhaps the final point to make about, the final point of principle to make about this, i.e. the suggestion that you should be, you're necessarily to be dragged into deciding whether or not there's incompatibility with international law of whatever type, is that on the current state of English law, that is not a necessary place for you to go. If you're standing back and judging the issue very generally by reference to the rule of law and legal controls and all of that, there are plenty of tools in the court's box for ensuring that the rule of law is properly protected. And I emphasise in making that submission that we are not in territory, as my learned friend Miss Kaufman submitted, where on the consequence of our submission would be that under domestic law you would be, quote, as she put it, without redress, or you would be, quote, as she put it, denied access to court. Neither is the position. There would still be a claim under the Human Rights Act, to the extent that that was allowed under the relevant legislation in the Human Rights Act itself. We have not submitted that the Crown Act of State doctrine applies to cut out any allegation of torture. We are not relying upon it, just to make this clear, in the context of the allegations that Sardar Mohammed made about ill treatment at the hands of British servicemen, which on no view amounted to torture. That is not a plea which we have entered as a defence to that sort of ill treatment. And you will note in that respect to say...
Could you have done? And if not, why not? Could you have pleaded Act of State in relation to that? And what is... I mean, I'm inclined to think probably you could not. But is there a principle here, or is this simply that your clients, being decent people, haven't taken a dirty point?
My Lord, I think it's more than that. I mean, one can analyse it either as being something which it would be wholly inappropriate to authorise, the ultimate judger of that question being the courts, or you can analyse it perhaps on a slightly more principled basis, on the basis that however you conceive the Crown Act of State doctrine in the context that we are dealing with here, there is a question about assume it only covers military operations and all things necessary, take Lord Reid from Burma Oil. The principled way of answering that question is that there's nothing inherent in military operations that requires you to beat someone up or to mistreat a prisoner, any more than there would be if one was to drag that logic through to Nissan's case itself, any more than there would be in saying that you don't bivouac in the open, you bivouac in the hotel and you're allowed to smash up the property while you're there. So I think the principled answer would be inherency in military operations, and that's as good an answer as any. And in
so are you, because I wasn't quite clear yesterday, are you confining this defence to military operations?
My Lord, the reason you may be, I mean, I hope I tried to make it clear by reference to Lord Wilberforce and to the principle or the approach that courts tend to take, which is to recognise, particularly in a sphere of this difficulty, that there may be real advantage in focusing on the context and the facts that you have before you, Of course, I understand the idea that one has to raise one's eyes to the principled hills in order to test the limits of the principle. But I've deliberately not sought to try and cover the universe of things that might happen. My lady put to me the controversial, including particularly recently controversial issue of drone strikes, which no doubt will be coming up to this court at some point in some guise. But one can posit a whole series of difficult examples which may need to be argued about in future. But Lord Wilberforce was thoroughly alive to that idea in Nissan. You'll remember the passage. He sets out the bit from Wade. He says this is more of a description than a definition, and cases will need to be sorted out on a case-by-case basis.
Your own principle of you mentioned a moment ago that one rationalization of the limits might be that some things are not inherent in the process. I mean, that may also be a reason why it would be confined to the conduct of military operations, because it's very hard to think of any sovereign act which inherently involves the commission of torts other than acts of force.
Well, that's possible, although even with that conception of it, one might need to be a little careful. My Lord ended up with it being other than those things which can be properly characterised as being acts of force, rather than acts taken in an armed conflict or a particular type of armed conflict. One can imagine a series of sovereign acts that might be thoroughly regarded properly as being thoroughly necessary in the defence of the realm or for national security purposes. So I don't want to close the door on that.
This is 007's license to kill, is it?
Well, 007...
Oh, I think you might be thinking of surveillance and bugging.
I'm thinking
things
of
like
surveillance,
that.
I'm thinking of engagement with foreign liaison services, I'm thinking of all sorts of things that we have arguments about every day in the administrative court. But I don't want to close the door, and I don't want to duck Lord Wilson's question because it's an important one. But the principal stance we take is, and the course we recommend to the court, is to focus on the context you have here, which involves detention and transfers between allies in an armed conflict where those actions are inherent and or necessary for the purpose of the pursuit of those things. And if the principle runs in that context, then that will provide, on any view, that will provide the kernel or the hard core of the principle. It may or may not be possible then for the principle to develop incrementally outwards from that, and that will have to be the subject of detailed consideration when the next context comes along. But the reason, my Lord, is no doubt doubtful as to why I ended up where I did was because I started by saying in opening, the only principle I need is one that has these features. Yeah. And it ended up with military operations, things that are necessary, Lord Reed in Burma Oil and so on. So I don't shut the door, but I do say that that lies at the heart of it.
Just in this context, then, confining ourselves to it, do you want to say anything just briefly about on what basis would habeas corpus operate? On what basis could judicial review be brought in respect of or by someone who was in this type of detention? Would it just be non-justiciable, or would there be some claim, and if so, on what legal basis?
Well, we jolly nearly had that argument.
Yes.
We jolly nearly had that argument in whatever it was, June, a couple of years back, before they all signed the bit of paper saying they'd actually rather move from our custody in Afghanistan to a new and bespoke facility run by the Afghan authorities. And so we didn't, but in Hakim and Ismail, we jolly nearly had the argument about whether or not habeas would apply. You'll appreciate that that's a potentially controversial subject. You know that Macaulay and Gates said what it said about that in the context of American law.
Right.
And there may be further arguments to be had.
But hasn't Ramatullah in this very case more or less
Ramatullah doesn't do that, because Ramatullah, if you will recall, was not in our detention.
I know, but the whole point was that we had sufficient control for us to be able to call back, or to at least ask for Mr. Ramatullah back, on what principle would, if we got him back, would then habeas corpus have proceeded?
Well, we didn't, I think from memory, I don't want to nitpick with my lord, but we didn't have sufficient control to make us effectively the detaining authority. The reasoning of the Court of Appeal, which you accepted, was that we had sufficient involvement / control to ask the question, to test whether or not.
That's in relation, to the legality of his detention by the Americans?
The legality of his detention by the Americans. If we detained at that point, query what basis we would have had for detaining.
The answer is if we got him back, we wouldn't have had any basis, yes.
Quite, because we wouldn't have been involved in the armed conflict at that point.
But yes, I see. So, I mean, I suppose the answer is that would you accept that if there was some policy, which I think there was, although Mr. Hermer was perhaps questioning it, but there was some sort of policy by the United Kingdom regarding the detention and review, even if it wasn't, we're considering how far it was adequate in the other case.
Then one might be able to review that.
Then you could review that.
But that would be an internal decision.
Right.
That's the explanation of the Hussein case that you were taken to this morning, which I was in, about interrogation techniques. But you recall that case, I can't remember, I think it might have been Lord Hughes who identified the emboldened passage, as it were, in the policy itself. But that same point comes out of paragraph 28 of the judgment in Hussein, namely, this was a policy that we promulgated. We bound ourselves through the policy to comply with the relevant international legal rules governing interrogation of that kind. But the reason that would be non-objectionable in our sort of context and doesn't cut across one voice is because you would be reviewing internally, pursuant to ordinary public law principles, a policy to which the government had chosen to bind itself. And that's an entirely appropriate and proper use of the rule of law, use of the court's primary function of holding the executive to account for the policies that it has espoused. Fundamentally different to the question of saying, if you move on to the international plane where the UK is acting as the UK, then you've got one voice difficulties, then you've got the problem, and you also have the additional problem in our context, which is that ordinary choice of law rules normally throw one into the foreign law. And so you've got that fundamental problem of ending up having to justify your detention pursuant to a system of law which is fundamentally unsuitable for that purpose. So that's the explanation of the Hussein case and the Rahmatullah case. My Lord, sorry, just to go back one step and just to invite you to have a little look at some point. Sorry to give you this, I know it's irritating to not take you to particular parts of academic articles, but Bundle 8, tab 89, page 12012, in an article by Professor Wade, there is a little section which is headed Act of State as Violation of International Law.
Now, is this ECS or HWR?
ECS. Thank you.
Where do we find that?
That's in Bundle 8, tab 89.
Page?
12012. Again, I'm not inviting you to read it now, but it's at least of some interest on that international legal point.
I think we're almost at time.
My Lord, I am, and I'm very nearly...
12012.
12012.
Thank you. Yep.
2 points finally, if I may, one shorter than the other.
It's inevitable.
The penultimate one, they're both very short. The penultimate one is that my learned friend Ms. Kaufmann accepted, I think in her submissions, that if you were acting in pursuance of a treaty, as she put it, it would be an act of state. It would be covered by our principle if you were acting pursuant to a treaty. And we respectfully agree with that, but respectfully submit that she needs to confront the logic of that, if that's a thing that she accepts. And the logic of that is to ask the question, what is the difference, if that is right, between that, i.e. acting in pursuance of a treaty, and acting in pursuance of authorization given, forget about whether it's authorization or obligation, but acting in pursuance of an authorization given by the United Nations Security Council.
I'm so sorry to interrupt, but can I just make it clear that when I was talking about a treaty, that was how Act of State was conceived historically. But I then went on to make the point, we do actually exercise jurisdiction in relation to even UNSCRs?
Well, I'm sure we do in certain respects, and in certain respects they are relevant for the purpose of justification of Article 5 detention. But if the logic of the argument is that an act of state can apply when you are directly implementing a treaty, the question of principle I pose remains.
Yep.
Why should it apply to that situation, but not to an authority given for the thoroughly important purposes for which the United Nations Security Council acts? Finally, in relation to Mr. Hermer and the Sardar Mohammed facts, I'm not sure, if I may respectfully say so, that the court on the issues that confront you today is likely to be assisted in any shape or form by someone standing up and reading out 7 thoroughly controversial propositions, assertedly of fact, which are the subject of ongoing debate, ongoing argument. You've already had some of it in the context of Article 5.1 in the hearing we had in February. You're going to have more argument about it in the context of the hearing that's coming in October. We do not accept any of those controversial propositions that were advanced in relation to Mr. Mohammed's detention. But in any event, and perhaps more fundamentally, the real problem for Mr. Hermer's client is not in relation to the facts of his case. It is that he has to assert, for the purpose of the Crown Act of State argument, that the appropriate system of law by which the legality or otherwise of his detention falls to be judged is Afghan law. And under Afghan law, as we all know, he would have been, if Mr. Justice Leggett is right, unlawfully detained 72 hours afterwards, even though the only place to which he could have been released after that time was back onto the battlefield.
Was where, sorry?
Back onto the battlefield, which we respectfully submit illustrates as clearly as anything could do the unsuitability generally of local municipal law applying to govern the legality of detention in a sphere such as this, and illustrates as clearly as anything could, in his specific case, the inappropriateness of that being the rule. Lord, my lady, those are my submissions in reply.
Very much indeed, Mr. Eden. Well, thank you all for your oral submissions on this matter, or these 2 matters, and thanks to everybody who was involved in the preparation of the cases. We will consider this matter and let you know our decision in due course. Thank you all very much indeed. The court is now adjourned.
Sorry.